And welcome back to the Gym Owners Podcast. On this very special episode, we have JoAnn, aka Dr. Jess, president and founder of the Fitness Law Academy. Dr. Jess is also the author of The Law for Fitness Managers and Exercise Professional, a book that I think owners, fitness professionals, high-level executives at big box club should have in their back pocket, because it describes over 110 different lawsuits that have occurred in fitness clubs, effective risk management. She even gives some forms and documents and various legal and risk management resources. Did I get that correct?
Yeah, that's great. Thank you. Perfect.
Got it. All right. So is there anything, why don't you tell us a little bit about your background? Because I know you have a ton of experience in the fitness world that will, it's more than how old I am. So I'll let you go back into your experience and tell us.
Age here.
Yes, I'm sorry, not mean to be ageist. I'm just saying you have so much more experience than any of us on this panel. Give us a little bit of your background.
Yeah, well, thank you very much for having me. I appreciate the opportunity today to do this for Gym Insight. It's been great so far. So anyway, I just have been in the exercise profession from the get-go. It's been almost 50 years since I've been involved in this profession. And I worked out in the real world for about 20 years. And then I went back and got my PhD, and I was really interested in legal and risk management topics because they always were coming up. And I thought, well, let me go back and go to school, learn a little bit more about this. And so the last 30, 35 years or so, I've been really focusing my teaching and research on legal liability and risk management for fitness managers and professionals. And so I did a lot of teaching at the university, taught classes in the legal area. And most of my writing and research has been in the legal area as well. And several years ago, I guess it's been 6 years already, that I retired from USF in their exercise science program. And I loved teaching and conducting research. And so after I retired, I decided I still want to do that. And so developed the Fitness Law Academy, which is the mission is really to provide legal education for fitness managers and fitness professionals. And I continue to do a lot of writing, textbooks and columns and that kind of thing for journals. And so it's been a very exciting career. You look back and you go, would you have done anything differently? And nope, I've loved every bit of it. And I learned so much from every job that I've had and all the experiences that I've had. And so it's been a great career, and it's a great opportunity now to do what I still love doing, which is teaching.
That's awesome. That's awesome. Have you ever had people that have had your book that was like, thank you so much, this has saved me from a lawsuit? Because I can tell you, the book is 10 times cheaper to read it and protect yourself rather than paying a lawyer after the fact you got yourself in hot water. So I was curious about that.
Yeah, we've gotten a lot of great feedback from the book. I haven't had anybody tell me that it prevented a lawsuit. But they are focusing on risk management, and helping to keep their fitness facilities and clubs safe, as possible. Because they're implementing a lot of the risk management strategies that we cover in the textbook. And so I think they feel a lot more confident about what they're doing and their job responsibilities as having exposure to the book and all the different documents and everything that we have in the book. So yeah, I think it's been very well received. And we have several universities now that have adopted the textbook for a class that professors are teaching. And one of the courses I teach is a faculty training course. I'm teaching it right now in the summer, where we train, academicians on how to teach the legal concepts in their courses, or even develop an entire course, which is what we recommend. So, so it's been well received. Thank you for asking.
Yeah.
Got it.
Wonderful. That, like you were saying earlier, it's so nuanced. There's so many different laws and rules in this, and it's great that you have that available for the fitness professional community. So when we were talking earlier, you said that waivers also there's a lot more to them. And so where would you say fitness professionals go wrong with setting up their liability waivers, and what's a good rule of thumb that you would recommend where they can go to set one up?
Great question. And yeah, waiver law, as you mentioned, is very complex.
Yeah.
And we cover a lot of cases, waiver cases in the textbook. But it's really important to understand that waiver law is based on state law. And so you really need to know your state law, in putting together a waiver and developing a waiver. And there are certain states where waivers are against public policy, so they're not even enforceable. For example, in New York has a state statute that states that waivers are against public policy and therefore not enforceable in health clubs and fitness facilities. In another state, they might be against public policy because of a court ruling. For example, in Virginia, way back in 1992, the Virginia Supreme Court ruled that waivers for personal injuries, especially like in fitness facilities and health clubs, are against public policy and therefore unenforceable. So that's the rule or the law in Virginia, okay? So it's either by a court ruling or maybe a state statute that states that, they're against public policy and therefore unenforceable. Now, that's really in a minority of states. In the majority of states, waivers, are effective in protecting defendants, managers, owners, professionals from their ordinary negligence, okay? And that's really the goal of a waiver, is to absolve the defendants of their own negligence. So if you have somebody that files a negligence lawsuit against you, that waiver might protect you, okay? And so they're very effective. However, they got to be written very, very carefully and based on state law. And so we highly recommend that you have a lawyer in your jurisdiction, in your state, to prepare your waiver. Okay, so you make sure that it reflects state law in your state. And so I think that's really probably the most important thing, is that you want to make sure that your waiver will be enforceable if it's ever tested, okay, in a negligence lawsuit to protect you. And the other thing that I want to mention about waivers is that they protect against what we call ordinary negligence, but not gross negligence. So there's a distinction between ordinary negligence and gross negligence. So gross negligence, sometimes it's called willful or wanton conduct or reckless conduct. And let me just give you a couple quick examples, because I think that's the best way to understand. Actually, to understand the law is to review case law. That's the best way to learn the law, is to review the cases that come up, like in our field. So this was an example where a trainer had an individual perform a brand new exercise, okay? And toward the end of this exercise, he became very symptomatic. He became nauseous and lightheaded. So they let him rest a little bit. But then the trainer said, let's have you do it again, okay? Well, then when he attempted to do the exercise again, he ended up with a very serious injury. And so he sued the trainer and the club, okay, for negligence as well as gross negligence. And the court ruled that the trainer was grossly negligent because she attempted to have him do it again after she knew that he had some trouble doing it the first time. So when you know something, you know that there might be a risk, and then you don't really pay attention to that, that's an example of gross negligence. Let me give you one other really quick example, and this would be more related to management and the maintenance of exercise equipment. Right? So in this particular case, somebody got hurt on a piece of exercise equipment, and this was a treadmill case, and the fitness facility failed to follow the specifications in the owner's manual, which required 6 feet clearance behind the treadmill. And they only had 3 feet or 3.5 feet clearance. This person fell off the treadmill, hit her head, had a severe head injury, And the court said they knew that they were not following the specifications in the owner's manual regarding clearance, and therefore they were grossly negligent. So it really comes down to prior knowledge of maybe a possible, danger or risk, and not doing anything about it, or not reacting properly to it. And that's really, what gross negligence is. And so it's important to remember that, waivers do not protect for gross negligence, only ordinary negligence. And so another good reason to make sure your instructors and trainers and the managers are, doing what they're supposed to be doing. And so they don't have that, that liability associated with gross negligence. We have several cases in the book where the defendants were found grossly negligent. And so those are just a couple examples.
Wow.
You don't have to go quick. I like when you're telling these things, I'm sure everybody that's watching this is like, I want to hear more of what's going on, so just to be fair on questions, you don't have to give quick examples. Like, I'm loving that, like, these explanations so far.
Yeah. Well, and it's really helpful for owners because there's that distinction there. Sometimes they think maybe, they have a waiver, and whether it's ordinary negligence or gross negligence, right? That matters. And when you were saying earlier that there are certain states where a waiver doesn't even stand a chance. So what would happen in those instances where, like New York, they don't have a leg to stand on with a waiver? What would you recommend to gym owners there? Because how do they protect themselves?
Yeah, that is a great question. And I get that question a lot. And again, this would be just a minority of states where, maybe the waiver would not protect you for ordinary negligence. The next best thing, is an express assumption of risk document. And of course, this is also a legal document that would need to be reviewed and prepared by, a competent lawyer. But this particular document pretty much outlines all of the risks associated with the activity. And so that the individual becomes well informed of those risks. Okay. And what that does, and of course, even that kind of language, a lot of times you do find in a waiver. So one part of the waiver might inform the individual of all the risk, risk of injury, like minor injury, major, life-threatening, even death. That's usually a paragraph within a waiver. But you can have, like, in a separate document, an express assumption of risk that gets into that in a little bit more detail. And so that would be the document we would recommend. Now, what that does, the language in the waiver informing them of the risk, or a special document, an express assumption of risk that they would sign. Basically, what it does, it strengthens what we call the primary assumption of risk defense. So oftentimes, and we have a whole chapter on this in the book, on negligence and defenses to negligence, there are two major defenses, the waiver defense as well as the primary assumption of risk defense. And so the primary assumption of risk defense can be effective in protecting defendants if, big if here, if the individual knows, understands, and appreciates those risks and voluntarily assumes them. Okay. So that's one of the, there's a lot of discussion in legal cases regarding the primary assumption of risk defense and how the courts analyze that and whether or not it's an effective defense. But it can be, and that's probably your next best approach, is to have a document like that, which would be legal, in all states for an express assumption of risk, as far as I know. And again, you would check with your legal counsel on that. So a primary assumption of risk is another one of those defenses that's kind of complex and kind of difficult to learn. And so we, have some cases that kind of help explain it to them. And, one of the reasons you really want to have beginners, people that are just brand new to exercise or a beginner, you want to provide some really good instruction for them so that they can then assume the risk, but that won't happen until they really have proper instruction and some experience with the new activity. And after that, they should be able to assume those risks. But there's been a lot of cases where beginners, did not understand and appreciate those risks, and therefore the primary assumption of risk did not protect the defendants. So I know that gets a little bit kind of convoluted, but it is a major defense along with the waiver defense that's used. But, so there is an alternative document that express assumption of risk that can be helpful.
I bet the waiver is more just so because, I bet you 80% of the time it's people like, oh, dang, I signed that waiver. I can't, that probably protects more than the actual, because in New York, I'm in New York and people still, they still have waivers. So I'm assuming they're only doing that as a psychological psych out to where the person thinks they can't sue because they signed this waiver that makes no difference at all in the state of New York or Virginia.
Right. Yeah. And I know there are facilities that do that. They have them sign a waiver and they know that it probably wouldn't be enforceable in their particular state. And, I guess that, if they are doing that, I think they should do that.
They're crossing their fingers.
Yeah, upon the advice of their legal counsel, too, because in some respects, you always want to be honest, with people and the documents that they're signing and, that kind of thing. But, anyway, that I know that happens. And again would, recommend that you'd have your legal counsel, give you some advice on that. If you're going to do that, have a waiver.
If you were going to, let's just say you're going to open up a gym, right? So what would you do? Would you do a waiver and a release of liability just to try to protect, assuming you're not in New York or Virginia, would you have both? You're opening up your own gym, what would you do as your waiver or just do both at sign up?
Well, usually we think of a release of liability is really a waiver. So sometimes those two terms can mean the same thing, a waiver and a release of liability. And if I was opening up a gym, would I have all of my new members or participants sign a waiver? Absolutely. And even though I would be very careful, as a manager to make sure, I have all my risk management strategies in place, all my employees would be very well trained and educated. I'd be following the law and everything as best I could. However, sometimes, people sue you. Okay.
Yep.
And sometimes you go, well, wait a minute. That injury was not due to our negligence. Okay. It was due to maybe your negligence or your misuse of the equipment or, whatever it might be. Or it was just an inherent risk. You fell. Okay. And you fractured your ankle, and it wasn't due to any negligence on anybody's part. But one of the fastest ways to deal with that lawsuit is, tell the court, they signed a waiver, so even if it is negligence, let's drop the case, dismiss the case, and the court would look at that and most likely dismiss the case. And so that's one of the reasons I would probably have them sign the waiver, as well as, you never know when somebody could be negligent. Any one of your employees, anytime, could be negligent and cause an injury. And so you don't want that to happen, but it can because everybody's human and humans make mistakes. And so, for several reasons, I would, definitely have a waiver and a waiver that was well written and prepared by a competent lawyer.
And I love by the examples that you've given us already. And by the way, again, her book has 110 different cases. So, and just because, again, I love stories, that's how it sticks out. I learn, I never forget it when somebody tells me a good story. Was there any other lawsuits that really sticks out to you where someone found themselves in trouble that, could have been prevented?
Yeah, I would say every case in the book, all of those situations could have been really prevented. Good risk management and creating a safety culture. I like to think of it as creating a safety culture within your facility. But let me just give you an example of one case, and this kind of gets into our chapter on exercise prescription and scope of practice. This was a trainer. He had a client who had osteoporosis. He knew that she had osteoporosis. And so one day during a training session, he had her do jumping repetitions on a bozo ball. And she fell and fractured her ankle. Mm-hmm. And so she sued. Okay, she sued the trainer and the facility. And again, what the court looked at was, okay, did this particular trainer design and deliver an exercise of program appropriately for this individual with osteoporosis. So the court looked at the type of participants. So in this case, this was a woman with osteoporosis, and the nature of the activity. So these are two things that courts will look at in determining negligence. And so the nature of the activity, jumping on a bozo ball, very risky. People can fall. And knowing that this person had osteoporosis, the trainer should have known that a fall with somebody with osteoporosis could lead to a fracture, a very serious injury. And so in this particular case, it would probably been best from a scope of practice perspective that this trainer probably should have referred this client to an exercise professional that had some knowledge and skill on how to design and deliver a program for a person with osteoporosis. And of course, nowadays we have so many Americans with all different types of chronic illnesses. And, so the exercise professionals, the fitness instructors and trainers and so on, they really need to understand what precautions they need to take given the individual's health history and their fitness status. And so that's really important from a scope of practice perspective and exercise prescription perspective. Let me give you another case. Obviously, when an injury does occur, you want to make sure you have an emergency action plan in place. And so that we have several examples of facilities that had failed to have a proper emergency action plan in place. Primarily, if they had a plan, it didn't work. Like the staff didn't know how to carry out the plan. So let's say, for example, there's been some cases where a participant has had, a sudden cardiac arrest. And to save that person's life, you need to use an AED. And there are several states now that require fitness facilities, health clubs to have an AED. Yeah. And the requirements within these AED statutes really vary from state to state. And so, again, that would be another area that would be really important for managers, to consult with their legal counsel. What are those AED statutes that might apply in our state, and what do we need to do? We need to have an AED. Are there training requirements? Do you need to, a lot of times these AED statutes require regular inspections and maintenance of the AEDs. There was a case, I believe it was in New York, where the fitness facility had two AEDs and neither one of them were operable, and the person died. And so that lawsuit was a very interesting lawsuit because the court said, you needed to have an operable AED based on state statute. Right. So, those are just, again, a couple examples. And that's why it's so fun for me to read these cases, these negligence cases, because you learn so much from them. Like you said, Anthony, it's like a story.
Yeah.
In a way. What happened?
That's exactly what happened. I want to hear more. So her book, it'll be in the link in the description.
Yeah, I know. How awesome, though. For you, it's neat. You have all of these case studies, but for any owner or, at that point, it should almost be like a no-brainer as far as knowing the law, making sure that you have all of that safety culture in place to prohibit yourself from entering into that risk. Like, why as an owner would you not have or abide by whatever the statutes are for that state with law and safety and everything else? Because, it makes all the, I don't know. I would think it would be a no-brainer. If I was a gym owner, I would say, hey, I want this book and I want to know what I need to do so that I don't fall into that. Like, oh, my headache. Geez Louise. So that's really interesting. And that leads us into insurance because, you're going to, like you said, people make mistakes. You're going to have things go awry, even probably with all of the safety measurements in place. And what would you I guess what would be common insurance mistakes that owners might fall into, or fitness professionals even, in owning a facility?
Yeah, another really good question. So, once that negligence lawsuit has been filed against you, first of all, you want to be able to defend it either through a defense like the waiver defense or the primary assumption of risk defense. And there might be other defenses as well that might be applicable. But if those defenses don't work, and you're found liable, okay, for the injury, your best bet then is to have your adequate insurance, liability insurance. So for a management perspective, it'd be really important for managers to review those insurance contracts very, very carefully. There's some cases in the text where we talk about where the managers really didn't read the contract, and there were exclusions in that contract. And then that ended up kind of hitting them on the back end, okay, so to speak, because they didn't carefully review those exclusions within that insurance contract. And so you want to make sure that your insurance contract covers all of your programs and services, first of all, that you provide. And any time that you develop, let's say, a new facility like a climbing wall, okay, or a new service of some type, that's something new that you want to do, like outdoor fitness or whatever it is that you're going to do that's maybe new, you would always want to check with your insurance provider to make sure that that new facility or that new activity is covered in that policy. And if not, you might need a rider or an addendum or whatever to that policy. Now, for fitness professionals, we really recommend that they have their own professional liability insurance. And if the management does not provide that for them, we highly recommend that they purchase it on their own. And really, I think managers should require that their fitness professionals, their trainers, instructors, have that professional liability insurance. And it's even best if they provide it for them and pay for it. But if not, professionals can obtain their professional liability through a professional organization. If they're a member of an organization like ACSM, American College of Sports Medicine, or other professional organizations, they can actually obtain that professional liability insurance at a very low cost because it's a group plan versus an individual plan. So that's what we really recommend. Those are a couple of recommendations related to, insurance from a management perspective and a professional perspective.
Yeah.
I have a question. You brought up the trainer, the case study about the trainer with, where they broke the ankle. Well, I know there's some gyms out there like, well, I don't technically have trainers. I 1099 my trainers where they just pay me rent every month. I'm assuming can the gym still be sued even if it's not the gym's trainer and the gym is just paying rent to train at that facility?
Well, that's another really good question. Okay. And we cover a lot of that in Chapter 5 on employment issues. I'm thinking what you're saying, Anthony, is that they're hired as an independent contractor versus an employee. And so
some places the trainer actually has to pay the gym to work there, and they can, like, instead of having your own personal training studio or whatnot, some gyms will actually sell like a monthly rent, and you could come whenever you want with whoever you want. You could use all my equipment.
So it's a contract. The management has a contract with an independent contractor,
right,
to come use the facility on a monthly fee or some type or whatever. So what if that contractor, okay, hurts somebody in your facility? So that's the question, right? So a couple of things. First of all, in that kind of scenario, management really doesn't provide much control over what that person does or doesn't do. Whereas with an employee, you have quite a bit of what we call behavioral control. So the IRS makes this kind of determination whether a person is an employee or an independent contractor. And so if a manager has a lot of behavioral control over an individual, the IRS would say that's an employee, not an independent contractor. Even if you call them an independent contractor, they might not really be an independent contractor. And some health clubs have gotten into trouble because of that, because they misclassified their individuals that work for them. In this other scenario that you have, it would probably be, the contractor would be liable, okay, for an injury to a client, for example. Generally speaking, that would be the rule. However, think of the scenario where the trainer is having the client work on a piece of equipment that has not been well maintained according to the specifications. Then who is liable? Could both parties be liable, okay, for an injury that occurred on a piece of equipment that the facility owns and maintains? Okay, so that gets into, again, some legal issues where, these contracts that management is putting together definitely should be reviewed by a competent lawyer and thinking through all of these various scenarios to help protect the management, as well. And of course, if somebody gets hurt on a piece of equipment, because of poor maintenance, the general liability insurance would maybe kick in. But again, if they don't have any maintenance records, this is another issue with equipment maintenance that comes up quite a bit in cases where, they know they're supposed to be maintaining their exercise equipment, but they have no documentation that it's being done. So there was one case against a health club where, the defendant said, "Oh yeah, we do the maintenance. We're doing it." And the court said, "Okay, show us the evidence where you have done the maintenance." And they had no records or no documents. And so the court basically said, "Well, you have no records, no documents, therefore you didn't do it." Okay. Therefore, you failed. You were negligent in not carrying out that responsibility. So anyway, I don't know if that answers your question or not, but, a lot of factors, I think, to think through with your legal counsel on any kind of contract, that you're setting up.
I've already learned, if you're going to do your own maintenance, make sure you're keeping books, because I guarantee you a ton of people do not do that. So there's already a couple things that I've learned on here that I hope if whoever's watching can learn. And there's so much more to learn in her book. But Natalia, do you have any other questions you wanted to add on to that, to the insurance?
Well, no, I was just going to ask you, because you had said something about the contract between the owner and, say, the independent contractor, that they would. So you're saying that as a gym owner, if I were going to rent space to a trainer, that I should have them sign a contract as well in order to, would that make a difference? Is that kind of also what you had said?
Yeah.
Where you had a agreement between that?
Yeah,
Okay.
whatever the arrangement is or the agreement is between two parties, it's always best to have that in writing, and where both parties, sign the contract, and again, having it reviewed by legal counsel. Yeah.
So even if they did say I was a trainer and I'm renting space from a gym, but it was, and we signed this contract with the gym owner, and then, I'm working out at whatever piece of equipment and the equipment was not maintained. So in that regard, even if I had signed this contract, the gym owner is going to be responsible too, right?
Yes. Yes.
Everyone's suing each other. The client's suing you, you're suing the owner.
And there's been cases like that, where there's these, multiple lawsuits, and, one injury, but they're suing this party and this party and this party. And so, but yeah, that can happen, and so the gym owner could be liable for not properly maintaining the exercise equipment, so they might be suing, the injured party might be suing, multiple, individuals or groups. Yeah. Uh-huh.
Wow. Oh.
Yeah, nothing's really easy, but and I always tell my students and other professionals, that I've worked with over the years, you do the best you can, and you get well educated, well informed about the law, legal liability, risk management. You have an advisory committee. I highly recommend having, your legal advisors, your insurance advisors, medical advisors, that help you form your risk management plan. And by risk management plan, I mean a comprehensive plan that really covers all these major legal liability risks. And it takes time to develop a good risk management plan. It's not something that happens overnight. It might take several weeks or months really to kind of think through all your policies and procedures that you should develop that reflect the law. And so, it's a major undertaking, but it can be done. And I know people have done it, that are managing programs and have done a good job of it. And they're always thinking about it, always keeping safety in front of their staff. Like at staff meetings, we have a safety, topic, every day at every, meeting or training session or whatever. Safety is always a focus, and we can always make improvements in our safety. and developing that culture within your facility and with your staff members, I think is important, and, helping them learn as well.
I was going to bring up too, because with that, right, I teach Pilates. That's like another one. And I'm a trainer, I do it all. But, in a class setting, you can't really mitigate as much. I mean, it's hard to, because say you taught group fitness, right? There's 30 people in there.
Yeah.
Or I teach on reformers, there's 12 people.
Okay.
So, like, what does a facility do in the group setting, right? Because those people are going in, they're accepting that risk. I'm not going to be able to individually help each person with each thing. There's 12 bodies I have to be aware of, or there's 30 bodies I have to look at. So what does an owner do in that regard? I mean, because I'm sure that someone could take a group fitness class they're not really ready for. And, like boot camp, they're supposed to be in the active aging, whatever, at basket week. And then, so then how do you say, well, hey, you're not supposed to be in my class, right? But there's 30 people there. What is the...
Yeah. Yeah, I think, you bring up a really good question, and I appreciate your experience as an instructor, because I think, as a group instructor, first of all, you want to make sure that your group instructors are well educated and well trained, that they have those, teaching skills, and how to maybe teach an exercise at kind of a low, moderate, and high risk or high intensity levels, especially with beginners, and how to modify exercises for beginners when you have a new person come into your class. And so again, a couple things that I would recommend, I highly recommend, matter of fact, that fitness facilities have beginner classes. I don't care what type of group exercise class it is, boot camp, indoor cycling, I don't care, but if you can, to offer a beginner class, because once they have that instruction and that experience, then maybe they're ready to get into kind of a typical or traditional class with all different types of levels of fitness. And it will make it easier for the instructor as well, knowing that this person has had at least some level of instruction and training on this activity. There's been some really good case examples with indoor cycling, where the beginners did not have appropriate instruction and they ended up getting hurt. And, mainly a lot of times with indoor cycling, there's a lot of research to show that it's a high intensity program, but I think it can be low intensity if it's taught at a low intensity level, if the instructor knows how to do that. One of the cases where I was an expert witness for, it was an indoor cycling class. And the instructor and the manager of this facility, I don't know if they really knew what they were doing, because this beginner came in day one, went through the typical indoor cycling class, very high intensity. They did not provide this beginner with any kind of instruction on how to keep the intensity low, how to use the bike, blah, 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 all the different things that you would, normally instruct a beginner. And so this individual the next day ended up with a very serious case of exertional rhabdomyolysis and was hospitalized, and compartment syndrome, where her quadriceps muscles, they had to do emergency surgery to save her quadriceps muscles. And so the lawyer in this case had hired me as an expert witness, and they just failed to follow even all of the instructions in the cycling manual. The cycling manual said about, well, this is how you teach, warm up, stimulus, how to monitor intensity, blah, 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 all of these guidelines on how to properly teach. And they really didn't follow any of those standards or guidelines regarding teaching. And so that's another thing I think with group exercise classes, is that you want to make sure, that the teachers know what they're doing, know how to teach a beginner. We recommend, if you can't offer a beginner class, and sometimes you just can't do that, a facility just can't do that. And let's, again, just using the example of an indoor cycling class, you would have that new member come maybe 20 to 30 minutes early, and that instructor would spend some one-on-one time going over with them the basics. I think the management should set up a checklist, or maybe the group exercise coordinator would set up a checklist of everything that new beginner needs to know about, indoor cycling and starting on day one. And then they would document that. They would document that they received this instruction, and you would file that document away so that you could at least demonstrate that they did have some instruction, And then the other thing, that in a couple of cases where the beginner is told to go to the back of the rooms for the indoor cycling class. And I'm like, well, that doesn't make any sense. Why don't you have them sit up front so the instructor can closely observe them, for kind of signs and symptoms and so on, keep a close eye on them. And, some really basic things that you think are common sense, but sometimes even common sense doesn't exist.
Goes out the window.
So anyway, those are just some examples of some cases that have happened, with group exercise classes. And so, all of these, like the boot camp and, yoga, there's a lot of injuries with yoga. And again, because they're doing advanced movements or poses way before they're ready. Okay. And then they end up, having an injury. So a lot of times I think the injuries are due to the exercise being too intense, given the individual's, exercise capacity, or the type of exercise, like jumping up and down on a Bozo ball, where there's a risk of a fall. So, those are the two biggies, I think, when it comes to, injury prevention, is to think of the type of participants and the nature of the activity, So very, very important factors to think about.
So in a group setting, you're saying that, like for an owner who was going to offer classes, that they just need to either offer a beginner level, or they would need to have some kind of one-on-one instruction prior, so that that person is aware of the risk that they're getting into when they take that type of class.
I think, those are kind of just some general recommendations, but then also that teacher does have responsibility, in teaching that class and watching the people in the class to make sure they're performing the exercises correctly. And if not, going over and helping them or whatever. A really good group exercise instructor can be teaching and helping individuals, as they're teaching, if they have that skill level,
Yeah.
and then also, teaching participants about just even, basic principles of safe exercise. Why do we do a warm up? Okay. Why do we monitor your intensity? Why do we do a cool down? Why do we modify exercises, based on the person's fitness levels and health status and so on? So, I think educating the consumer about some of these things, a really good teacher and trainer also does. It's not just leading them through activity, but actually teaching, exercise.
I left a studio for that reason, actually. They didn't have a leveled system or a beginner system. And it doesn't matter how great an instructor you are, that if you have somebody and you don't have a beginner level, especially Pilates, where there's so much risk because standing and you're this, and that the people would come in who were 70, had never been on a reformer. And I would feel so uncomfortable because it doesn't matter, the 90% of the class you're trying to teach to their level. And then you have someone come in who's like a fish out of water. So I would say, I'm so sorry, but I can't teach you in this class, so that they would not risk injury. But thankfully, the studio I work at now has exactly what you said.
Good.
Good for you. Yeah. So we'll come back beginner, and we do like an intro to show them how it works. And so that it's like, because you do, as an instructor, you have heart palpitations, especially like the season one. And you see someone who you're like, wait a minute, they're really going to injure themselves. And there was a gal that I worked with who had years of experience teaching Pilates, and she was teaching just 2 people. And I heard her say it 10 times to this guy, slow down, right? And he didn't slow down. And the bar slipped out of his hand. It snapped him in the eye.
Oh, wow.
Lit his eye open. But she had given him the right instruction. So at that point, she wasn't negligent. It was his doing. But so I guess it doesn't matter. But like you said, the class levels and making sure that you have that for your consumers, your customers, is important as an owner to mitigate any kind of risk later, where those people are coming in and feeling safe in the type of workout that they're doing.
Yeah, I think you've also brought up a really good point about, when a participant, whether that would be just somebody using the facility on their own or if they're in a class, and they're not really following what you instructed them to do, or they're not following your safety policies and whatever. And you've tried to provide that education to them, and you have, an example of what you have said to them on what to do properly and so on. We have what we recommend in the textbook in our chapter on instruction and supervision is not only just to have a lesson plan, but to have also a lesson plan reflection or evaluation. So at the end of every class, the instructor fills that out, and maybe nothing happened that day. So you just mark nothing happened that day. But then you have maybe situations that come up where maybe you've noticed somebody who is continuing not to follow your instruction, okay? Or you have somebody that comes up to you and says, I've had a lot of knee pain the last couple of weeks. What should I do? And then, of course, you can document what happened and what you said on this evaluation or reflection form, and then that's put away as a document that would help maybe, provide some evidence of, well, I did provide that instruction. I did provide proper guidance. I told this person if they've had knee pain for 2 weeks to seek medical evaluation, because it's that kind of person that then maybe a month later ends up with a knee injury, and they're going to going to blame you for negligence for some reason or whatever. And you go, wait a minute. We told you about what you needed to do about your knee pain a month ago. Did you do that? And so at least it's some, I guess, evidence or documentation of your attempts to provide instruction or attempts to, provide guidance. And people that misuse exercise equipment, and maybe the floor supervisor goes over and they instruct them on the proper use. And I highly recommend that you train your floor supervisors on how to approach people in a professional way, and all of that, and that we're here to help you. We want to make sure that you're performing the exercises properly and coming across in a very positive, professional way. But then people, continue to do what they're doing, and they continue to misuse the equipment. And that's where you document, you document the date that you provided the instruction, maybe even a second time or a third time. And some facilities have policies where, after 3 times you're not following our policies, we'll revoke your membership. And so again, in those situations, we would recommend that a policy like that you review with your legal counsel again, because, they might come back and say, oh, you're discriminating against me. You revoked my membership because of some type of discrimination claim. And so then you got to decide, okay, what's worse, a negligence lawsuit or just, I mean, it gets kind of convoluted, doesn't it? So, but, I think policies like that where you revoke a membership, you want to be careful about it. But, it makes sense to me, when people aren't following your safety policies that, they're injuring themselves potentially, or maybe somebody else. And you got to do what you think is right as an owner, So it's just another issue to kind of think about.
I don't want this podcast to end. It keeps I keep so interested in another story, like another case. I'm like, what? I think we should have her on as a monthly thing, like Jim Moore's Case Studies Edition. Like, this is awesome.
Yeah. I know, special Jim unit. It's like, wait a minute.
Oh, I know there is a lot to learn, that's for sure, and so, but yeah, I think your audience would definitely like maybe the course that I mentioned, the new law course that we have. Actually, the textbook accompanies that course. So you get the book and then you take the course and you finish the course and get your CECs. The other thing that I might mention, I also have a free newsletter that I offer through the Fitness Law Academy. It's a quarterly newsletter that comes out. I've been doing it for a little over 5 years now. And so I cover a lot of these topics. It's usually like 4 or 5 pages, so it's kind of a short read, but we cover some of the issues, and we always have some case law in each of the issues and try to, educate, fitness managers and professionals through the newsletter. This next one that's coming up in July, toward the end of July, it'll come out. Going to be focusing on the duties toward invitees. So your invitees are your participants and members in your fitness facility, and the law requires certain duties toward them. in terms of inspection of your facility and that kind of thing. So we'll get into that issue and some case law related to your duties toward invitees. And then the only other thing I would like to mention is we just started Instagram. You can follow us on Instagram, at Fitness Law Academy. We just started this. A colleague of mine who was actually a former student is helping me with this because I know nothing about social media. And so anyway, thank God she's been a great help. But we started posting some articles on negligence and gross negligence and defenses toward negligence and so on. So you can always follow us there on Instagram for information and education too. That's also free. So,
and you should also mention that you can be booked for speeches and workshops. But why don't you give us a little bit of what you do with the workshops? So like, does private clubs book you, or do like big box gyms have you do workshops?
I haven't really had a large request for, workshops. I do a lot of conference presentations over the last 30, 40 years. So that's, audiences from, the ACSM, athletic business, various groups, medical fitness association, various groups that have had me as a speaker for like that session at a conference. I do a lot of that. But in terms of if an individual or a manager or owner would want me to come in and do some training with their staff, for example, to do a workshop with their staff, I'm happy to do that. And they can contact me through my website if they have an interest in doing that. And I would really like to, gear the workshop toward what they would want covered. Okay. So, I can give them a whole bunch of topics. Okay. And then they can kind of narrow it down for maybe like a half-day workshop or something like that. If they wanted to, provide some kind of program like that or workshop for their staff members. And so I'm happy to, do that, if there's an interest in doing it. I was, I guess, kind of a lecturer for a university, had asked me to come in and do a session on legal risk management for all of their exercise science students. So they all got in this great big room and, did about an hour and a half presentation or, some of the legal issues and some of the credentialing issues as well, for, new exercise professionals. And so those things are always kind of fun to do. And so, yeah, I'm very open to it. It's just, a matter of, kind of setting it up and working it out to meet the needs, of their particular facility or gym.
Wow. So you got a book, you have social media now.
TikTok.
Yeah, TikTok is next. Yeah, do that. I think one at a time is good for me.
Yeah.
So, yeah. Follow you at the Fitness Law Academy, and we'll tell, all of our customers to do the same, because you just have a wealth of knowledge. And I've also learned we live in a very litigious society, so you got to be careful. It's nice. Yeah, you're right. And things have changed. Back when I first started this profession 50 years ago, litigation wasn't really much of an issue. We really didn't think about that. I started my very first job at a Y, working as a program director, and it wasn't really an issue. But nowadays, the last couple of decades or so, it's been, we do live in a litigious society, and you need to really kind of think through how to protect yourself and your business. So, yeah, very good point about the litigation epidemic, sometimes it's referred to.
Yeah. I know. Wild.
Well, I just want to thank you for coming on, because my favorite podcasts are when I take away from something. Like, I would never even thought that there was a lawsuit with a cycling class. Like, that's just...
Oh, yeah.
Yeah. Oh, there's Zumba lawsuits where like all the...
Yes, there are.
What?
Yeah. Yeah, we cover some of those in our Chapter 8 on instruction and supervision. We get into some of the group exercise negligence lawsuits, and, what went wrong and, again, how to prevent it. And again, I think, the beginner thing is the most important thing with the group X.
Yeah.
Well, you have any other questions, Natalia?
No, I feel the same as Anthony. I'm so thankful. I feel like this was so interesting for me. I just wanted to like get my ear closer because it was like everything that you wouldn't have. I mean, I hadn't even have thought through. Even working in this industry for 18 years, it's like, wow, there's all these different steps that you would need to take as an owner. And it's just so helpful. It's so nice that you do that and you offer that as a resource for so many gym owners who are really, they're just doing what they love to do and they have a passion to get in shape. The last thing you want to think is injuring someone or having that be something in your future, so it's nice, that it's important they follow those safety measures. I learned so much. So I'm really thankful that you came on. It's really, really beneficial for us. And I think for all of our viewers and listeners and our customers. So thank you.
Well, information will be in the bio, in the link description. So website, book, everything.
Thank you so much. I appreciate the opportunity. And if I can be of any help in the future, just you know how to contact me. So I'd be happy to get help any way I can. And so again, thank you.
I'm you on Instagram.
Just promise me on the next case that we just like goes, what just happened? You have to contact us. And we do a quick podcast to go over it.
Yeah, don't. Yes.
All right. Well, thank you so much again. And again,
thank you.
Follow Dr. Jess. Link is in the description.
All right. Thanks again, you guys. Have a great day.
Have a great day. Bye.